In this short video, we're going to look at an evaluation essay on intoxication. Evaluation essays appear on exam 3, and you'll have to answer one essay on criminal, one on contract, and one on tort. So this is an example of a criminal question. The question is, the defence of intoxication reflects the difficult balance between legal principle and public policy. Critically evaluate this statement. As usual, it's worth 25 marks and you would have 45 minutes to answer it. We're aware that the general gist of an evaluation question is what is the law, AO1, is it good or bad, AO2. But when you look at this question specifically, it's asking you about a difficult balance between legal principle and public policy. And that is getting at the fact, it's trying to give you a clue that the law on intoxication is quite complicated, because whilst we want to recognise that a defendant may not have formed the requisite mens rea if intoxicated, we also don't want to allow the defence of intoxication too easily. Otherwise, a defendant could escape criminal liability just by being drunk. And of course, that is not in the public interest. It's a public policy issue. The law on intoxication is quite complicated because of that reason, because we're trying to balance legal principle and public policy. So I've just included in my document a very simple table that illustrates how the defence works. And if you recall, whether the defence is available or not depends firstly on whether the crime was specific intent or basic intent, and secondly, whether the intoxication was voluntary or involuntary. Voluntary intoxication being where the defendant has chosen to take the intoxicating substance, the drink or drugs. Involuntary intoxication, situations where the person might have been spiked or having an unusual reaction to drugs. Specific intent crimes are where they can be committed through intention only, such as GBH Section 18 and murder. Basic intent crimes are crimes where you can be guilty of committing them through intention or recklessness. So examples will be assault, battery, ABH, GBH Section 20. So if we scroll down then to my suggested answer, as usual, I've made my AO1 comments in black font, my AO2 comments are in red font. Remember that you get 10 marks for your AO1, saying what the law is, 15 marks for your AO2, where you are evaluating or discussing whether the law is good or bad and why. You get 15 marks for that. So it's really, really important for this question that you're not just describing what the law is, but you're evaluating whether it's good or not. If you have a look at my introduction here, as you would expect, I've started off with a definition of what intoxication is. So I've said that it covers the effects of alcohol, drugs or solvents, but I've pointed out something quite important here, that technically speaking, intoxication is not actually a defence, but it can provide a defence in some circumstances if the defendant doesn't have the required mens rea. And then straight away I've got into some evaluation here, and I'm linking to the question by saying that the defence of intoxication draws complicated distinctions between crimes of basic intent, specific intent, voluntary and involuntary intoxication. And that's what I reminded you of with this diagram here. So the reason we've got these complicated rules and distinctions is to try and develop a balance between legal principle and public policy. And you can see I've directly linked to the question there in my introduction. That's really good practice if you can do that. And I've pointed out what I mentioned before, that whilst it's undesirable to convict someone of an offence if they don't have mens rea, it's also not going to be in the public interest for criminals to be able to escape liability by getting drunk. So the law on intoxication is complicated like this because it's having to try and balance again, wording from the question. It's having to try and balance criminal principles with the need for public protection and the encouragement of good behaviour. I've then started to go into my explanation of how the defence works. So I've said whether the defendant is guilty or not depends on whether the intoxication is voluntary or involuntary, and if the offence is specific or basic. And I've put an explanation of what that is there. And I'm going to start off with voluntary intoxication. So I'll explain what voluntary intoxication is, evaluating as I go. Notice a balance, black, red, black, red. I'm trying to explain the law and evaluate, so I've got a nice balance to my essay. So starting with voluntary, I've said that it can negate or it can take away the mens rea of a specific intent crime if the defendant is not able to form the mens rea. And then we've got that rather controversial case of Sheehan and Moore there. So Sheehan and Moore was the very unpleasant case where the defendants set fire to a tramp when they were incredibly drunk. The rule is if the defendant is voluntarily intoxicated and is able to form the mens rea, then they will be guilty. However, in that case, and it's quite a surprising decision, I think, they said that the defendants were not able to form the mens rea. Now, I've started to evaluate that case that I've mentioned there. So it can be criticised on a number of grounds. Firstly, it's not socially acceptable to be intoxicated, so it seems strange that we're allowing intoxication as a defence for the most serious of offences, for murder. Secondly, the jury believed that the defendants were so intoxicated that they weren't able to form intention to kill or intention to cause GBH. But to me, it seems extremely unlikely that they didn't have, at the very least, intention to cause GBH. It also seems illogical that we're saying that they're too drunk to form the mens rea, but sober enough to actually carry out the act. Surely if they were that drunk, they wouldn't be able to do the act that they actually did. So in Sheehan and Moore, they were voluntarily intoxicated, but they didn't have the mens rea. If they are voluntarily intoxicated and they are able to form the mens rea, then they'll be guilty. And that's because intoxicated intent is still intent. And we've got the important case there of AG for Northern Ireland and Gallagher. And that case is very important because it's telling us that you're not able to use alcohol as Dutch courage and then rely on the defence of intoxication. That would be very undesirable for the law, and there's a public policy issue there. So I've done voluntary intoxication and specific intent. I'm now doing voluntary intoxication and basic intent. And the rule is there that voluntary intoxication is never a defence for basic intent offences. And that's because, according to DPP and Majewski, getting drunk is reckless. And because basic intent offences have recklessness as their mens rea, you're essentially saying, well, you got drunk and that was reckless. The crime is satisfied by recklessness. So you've actually proven by getting drunk that you are reckless and you do have the mens rea. Now that case has been criticised by the Law Commission. So I've mentioned the case, I've evaluated it straight away. And the Law Commission said that the Majewski case seems to conflict with Section 8 of the Criminal Justice Act. And that's quite an interesting evaluation point there. Another problem with Majewski is that the defendant was found guilty because getting drunk was reckless, but this contradicts the rule that the actus reus and mens rea must coincide. Because the decision to drink, when you think about it, might be several hours before the actus reus is committed. In other words, I might start getting drunk at 2 o'clock in the afternoon, I might not actually commit the criminal offence until 9 o'clock at night. So it's not coinciding. Your actus reus mens rea are not coinciding there. So Majewski is making clear that intoxication is only available for specific intent crimes. And a critical point I could put about that is that that works with murder in Section 18 because there's a fallback position. But it's not clear about specific and basic intent crimes. Theft is seen as a crime of specific intent, but there's no basic alternative to this crime. So as I've put there, it's illogical that a jury should consider intoxication in determining whether or not the defendant had the mens rea, but not in relation to whether or not he thought himself to be acting in self-defence. So a bit of a problem there with the law. On the other hand, to try and be balanced, a positive thing about Majewski is that it's giving a clear rule. Clear rule, not allowed for basic intent. But there is a case called Richardson and Irwin. There have been other cases actually on horseplay, where cases of drunken horseplay involving the defendant have allowed intoxication, and that conflicts with the Majewski rules. It provides further confusion in this area. So I've dealt with voluntary intoxication there. I'm now moving on to involuntary intoxication. So involuntary, because your defendant has not chosen to be intoxicated, it can be a defence to specific and basic intent. You've got Hardy there. Hardy took his girlfriend's drugs because it was Valium, and he believed that Valium would calm him down. It would have a soporific, sleepy effect, if you like. But actually for him, it wound him up, and he actually ended up setting fire to a wardrobe. In this case, he was able to rely on intoxication. You could criticise it because taking someone else's medication should really be reckless, and it should therefore be voluntary intoxication. Hardy is also quite difficult when you compare it to the case of Allen, because in Allen, it was quite clear, made clear by the court, that if the defendant makes a mistake about how strong the alcohol is, that's his own mistake. That's not involuntary intoxication. So you can't drink beer and say, oh, I thought it was non-alcoholic beer. That wouldn't work according to R and Allen. But a critical point I've put there is there's surely little difference between not knowing the effect of a drug, Hardy, and not knowing the strength of wine, Allen. And yet these two cases have got two different outcomes. I've then got Kingston, very controversial case where the defendant was spiked. And in this case, it was held that drunken intent is sufficient for the mens rea of a crime, even where the defendant has been spiked. And it's questionable whether this represents justice, because arguably the defendant, he certainly maintained that he wouldn't have done the action, he wouldn't have interfered with this child if he hadn't been spiked and set up by the defendants. And that does seem like quite a harsh decision. If mistake is induced by intoxication, in other words, if your defendant makes a mistake because he is drunk, it's very rarely going to be an offence. And I think that's a logical ruling there. I'm sort of wrapping up here with my conclusion, and I've said that there are many problems surrounding the law of intoxication, and you can see that it's very complex. Different rules for voluntary, different rules for involuntary. I've looked at the Law Commission proposals for reform here. I've compared to possible situations that we could adopt, like in Australia and New Zealand. And I've ended on the 2009 report from the Law Commission. And they said that they could make an offence where the person had become deliberately intoxicated and caused the harm by a list of offences. And that would clarify the law. It would be a great improvement in terms of balancing law and policy, link back to the question there.